Thank you for our continuing education series at Jones & Company Realty. And we're really excited because land sale has brought us an attorney. So Kathy's going to give you a little bit of information about land sale and the attorney. And today, all the things you want to know about probate, trust, you've got an attorney with a fantastic Q&A. So rules of the day. If you're here in the room, raise your hand and holler the questions out. If you are online, please use the chat and we will take them in order, and Joanna will bring them out so the attorney can talk about them. If you want to share stories, raise your hand and we'll kind of go from there as well. All right. So without further ado, I'm going to get out of the way and go to Kathy.
Good morning. I'm Kathy Manczyko with Land Sale Title Agency, and I work from the Fort Myers office of Land Sale. My primary job is to earn your business and make sure we have a smooth closing. You send your title order to me, I assign it to one of our teams, and I monitor the closing process. But I think my passion really is being one of your business partners as a real estate professional. I think we all need somebody that we can call day or night, get answers. You're not dealing with voicemail, emails, not available till after 2 o'clock. So your business partners are probably very important to you. So I offer myself as a business partner to you with Land Sale Title, one of the top title agencies in Lee County. And today I'm so excited to bring to you Amy Neaher. I've known Amy for a few years now. Wow. Really shocked that she was able to take time out of her very hectic schedule to be here for the agents. And I am going to happily turn over the program, let Amy tell you a little bit about herself and get started on the program. Thank you.
Okay. Thank you, Kathy. All right. Yes. So my name's Amy Neaher. I am an estate planning, probate, and guardianship attorney. Basically, I just tell people I do death and dirt, which is true. Kathy asked me to talk a little bit about probate today. Years ago when I started doing probate, it really was, somebody died and my job was to kind of handle all of the assets of the estate. It wasn't long before I quickly realized how it tied into your business and real estate, because I started getting the frantic phone calls, usually right as things were getting heated and ready to go to closing. And all of a sudden, everything came to a grinding halt because the agent was told by the underwriter, you are stopped in your tracks and it needs to go through probate. And then, of course, I get the telephone calls. So what does that mean? What do we do? And of course, more importantly, how quickly can we do this? So my job today is to try and give you kind of an overview, really, of the different kinds of probate, because there are a couple of different kinds. And it really is fact dependent on what the situation is. I'm really only going to give you a really overview because there are a lot of quirks to it, and each situation can be a little bit different. But I'm going to go through, going to try not to confuse you. And I had some questions that were sent to me ahead of time, so I have an idea of the sort of things that you're looking for. And then I'm going to open it up for some questions, trying to give you my best answer based upon the information that you're going to give me. So with that, let me get started. So let me start off with what exactly is probate. So a lot of agents and even just some of my clients don't even understand what probate is. So probate is the process of moving an asset that is just in a decedent's name. There's not a joint owner and there's no beneficiary. Okay, so that person dies with a bank account, a piece of property. There's no other owner on that property or that bank account or whatever other asset, either through a beneficiary or a joint ownership. Okay, so the process of getting that asset to the beneficiaries is probate, and that's where the court system comes in. Now we identify the beneficiaries one of two ways, either one, through the will that the decedent left behind, if they bother to leave a will, and hopefully they did. But if you don't bother to leave a will, the Florida statute has a very nice plan for you. It's called our Rules of Intestacy, and it will say where your asset goes. Now, it may not be how exactly you wanted it, but clearly you didn't bother to take the time to put together a will, so clearly you didn't care. So it's going to go according to the rules of intestacy. And quite frankly, it just kind of sort of follows a little bit of your family tree. And it really just kind of looks, were you married, were there kids? If there's not any kids or wife or spouse, then are your parents alive, brothers and sisters. So again, you may end up with an uncle or an aunt or a niece or nephew owning the property. Again, might not be your intent, but without a will, that's what happens. All right, so we have a will. Let's assume there is a will. Now, so the first thing is we're going to look at the will. What kind of will is it? Is it a Florida will? It'd be nice if it was a Florida will, but what if it's a foreign will? Now, when I say foreign wills, people go, wait a minute, is this from Germany? Is this from Canada? No. It could just be from South Carolina, right?
The will being out of being foreign, what if they that make a difference?
Oh, yeah, that's coming next, actually. So, and that's not uncommon here in Florida, right? How many people, live someplace else but die with property in Florida, right? So the first way, or the first kind of probate is what we call a petition to admit foreign will. So this is usually where someone has died. Let's just say Mary dies in New York, okay? She's a resident of New York. She has a New York will. Let's say there was a probate that was already opened and closed in New York. But for whatever reason, maybe they forgot about the Florida property, or, and I'm not quite sure how this happens, but they didn't know about the Florida property, okay? But it wasn't included in that probate, but the will was probated in New York, but that probate is closed, or Mary's been gone for 2 years or more. We can just admit that foreign will to the court. It's called a petition to admit foreign will. And it's pretty easy. It's just a petition and an order. Now, it works if the people identified in the will are still alive, right? Mary and Joe are the beneficiaries. But what if Mary and Joe are not alive? Well, the problem gets a little dicey, because when we do the order, the clerk of the court is going to change the property to Mary and Joe. They don't know that Mary and Joe are dead. So that doesn't always work, but sometimes it does. And if it does, well, that's easy. Petition, order, boom, we're done. File the death certificate and you guys get to close, right? Okay. But that always doesn't happen because, again, Mary doesn't always die with a will, or she hasn't been dead for 2 years, or they never opened up, they never bothered to probate anything in New York, where it's still going on. So we can't do that. The second form of probate is called a summary administration. A summary administration are for estates under $75,000. Okay, so the assets of the estate have to total $75,000 or less. Now you're like, well, hang on a second, Amy. How does that work with real estate? Because that piece of property would have to be pretty cheap, like a lot. Yep, right. So it works really great for lots. It also works really well for homestead property. Homestead property, when we get it declared homestead property, is homestead exempt, which means it is exempt from creditors and it has $0 value. Okay, so when I file my petition for summary administration, I will list the homestead property and I will say exempt, $0 value. And then if I have a bank account, let's say the bank account's $50,000, this estate qualifies for a summary administration. A summary administration can be very quick if everybody cooperates. Okay, it's a petition. All right, it's just a petition and an order. Usually one of the family members, usually the person named as the person representative in the will, or it could be just one of the beneficiaries, will petition the court. We will identify this person died. Here's the will, or maybe there wasn't a will. Here are the beneficiaries in the will or under the statute, and here are the assets. And that's it. We get an order and we record it, the death certificate, and we're finished. All right. It's meant for estates that are not very big. It's also meant for estates that don't have a lot of creditors. Okay. This usually works when we have a lot, when maybe somebody is not, maybe somebody didn't even live here and they just had that lot, that they forgot about. Works very well. A piece of homestead property, right? 1, 2, 3. We can usually get it done in a couple of weeks. There's one particular judge. I don't know how we managed to do it. I like to file everything all at once. And I actually got an order the very next day. I know. And so we were finished. That's it. And the parties were able to close. All right. So under $75,000, good for homestead property. Other assets totaling under $75,000. Yes, ma'am.
Which judge can you submit and petition to?
So the question was, can we choose the judge that we submit? And the answer is no. I wish. So there are certain judges that are assigned, to probate court, criminal court, family court. They do a rotation, but no, we can't pick. I really wish that we could, because I do have favorites, but no, we cannot, unfortunately. I know, right? All right. What about the estates that the property is not homestead? What if the estates are big? All right, I have one on my desk right now. It's $20 million of assets. Yeah.
No.
Yes. Yeah, right. Okay. So those kind of estates are not going to fit into a summary administration. All right. So those are going to be what we call a formal administration. And most people are familiar with formal administrations, where you see letters of administration and publication in the paper and all of that. And most people from out of state are really familiar with that, because they're like, oh my goodness, this is going to take 5 years and we're never going to get done. Yes. So what happens in that case is it's really not so bad when it comes to real estate, because our goal is to get letters of administration, and letters of administration are the appointment of that personal representative who actually has authority to act on behalf of the estate. Okay, so we have to file the petition. We have a whole bunch of other paperwork that we need to file. But what ends up happening is somebody gets appointed the personal representative of the estate. They get issued those letters of administration, which gives them the authority to act on behalf of the estate, which includes signing the documents at closing on behalf of the estate. Now, getting those letters isn't going to take years and years, okay? It's going to take a couple of weeks, again, if everybody cooperates, okay? I put that caveat in there because there may very well be one of those beneficiaries, who refuses to sign anything, and then it's just going to take longer. However, if everybody cooperates, we can usually get letters of administration in a couple of weeks. All right. So once those letters of administration are issued, at that point in time, that person can act on behalf of the estate, and they can go to the closing table to sell the property. Now, there's a bit of a wrinkle. So typically, when wills are written, there's a clause in there that says that the personal representative has the authority to sell the property. But if the will doesn't contain that language, or the person dies without a will, we have to petition the court to ask for the permission. So that can add some extra time. All right. When I get these, I quickly look at the will. Am I going to have to file this motion right away? And so if I know that we already have a deal on the table, and sometimes there already is one, we will go ahead as soon as the letters are issued. I'll file that motion. We'll show the judge, this is an arm's length transaction. This is a fair deal. everybody, all the beneficiaries will have an opportunity to object if they object to this sale. Typically they don't, because they'd like to have the cash in their pocket. If there's no objections, we'll get the judge to sign off. Yes, go ahead, you can sell the property. If the language is contained in that will that says, yeah, go ahead, you can sell it, you have the authority, then we don't even need to do that. All right, so proceed to sale. Is the probate closed? No, it's not. There's a lot of other things that we may need to do. There might be some other assets that we need to deal with, but that has nothing to do now with the real property. Okay. So those are really the three main types of probate that we deal with. Somebody was asking about trusts, and trusts really have nothing to do with probate. As a matter of fact, if you have a trust, then you shouldn't be going through probate. All right. The whole point of a trust, well, one of the points can be to avoid probate. So if you go back to my first point where I said probate is moving an asset that was only in the decedent's name, right? No joint owner, no beneficiary. What if I take that piece of property out of my name? What if I put it in the name of a trust? Okay, and then I die. It's not in my name anymore, right? It's in this name of this legal entity, right? The Amy Neaher Living Trust. All right. The parties to a trust, I'm the trustor. I created the trust. I get to change it. I get to do whatever I want with that trust. All right. I'm the trustee of the trust, which means I control all of the trust assets. And in my trust, I have said, when I die or lose my marbles, I have appointed Bobby Joe to be my successor trustee. So when I die or lose my marbles, Bobby Joe now stands in my shoes to control those trust assets, which means that Bobby Joe can now sell that piece of property. Bobby Joe has ultimate authority to control that asset. It doesn't need to go through probate because it's not my asset. It belongs to the trust. Okay. Unfortunately, a lot of people will have trusts, but they don't fund trusts. They don't take their assets and actually point them to the trust or give ownership to the trust. So sometimes we'll have a very beautiful trust, but we'll still end up having to go through probate. Yes, the question was, we still have to go through probate because they didn't put the asset in the trust. And the answer is yes. If I die and my bank account, my property, everything is still titled in my name, then my trust is useless at that point. I could line my cat box with it. It really is. And I've had that. I had a gentleman who had a beautiful trust. When I say beautiful, I mean, as in, I think the paper was gold gilded. It was just gorgeous. Binder, everything. He paid a lot of money for this trust. And he came in and I'm asking him, okay, what are your assets? What are your assets? And I'm getting the blank. And I'm like, oh, no. Okay, hang on here. And he had some changes. And I said, all right, you know what? We need to kind of regroup here. I'm going to make your changes, but when you come back, we're going to tackle the funding of your trust. He died 3 weeks later. It turned out that he had never funded this very beautiful trust. He had assets here, he had assets in Michigan, and he had assets in Ohio. And when I say assets, I mean real estate, lots, and he just had so much stuff. Everything was in his name. So there was actually a probate opened here in Florida, a probate in Michigan, and a probate in Ohio. Okay. And ultimately we used the will, the pour over will, which basically pointed the assets through probate into his trust so his trustee could then manage it. So we got it into the trust a long way after he died. But the whole point and the money he paid for that trust was just, it was kind of a waste. And that happens a lot, unfortunately. But if you properly fund your trust, then you should never be going through probate with those assets. So one of the big questions that I always get from realtors is, when and who can sign the contract. So when is when the person in front of you, either A, is given the authority by the court, or B, owns the property. Okay, I mean, think about it. If you're going to enter into a contract, you really should have the authority to do so, or own the asset that you're trying to sell. And I know that a lot of times that doesn't happen. You know, oh my gosh, we've got a buyer, boom, 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 it's happening really quick. I've got this contract. I get that. However, the minute that you find that Betty Sue in front of you doesn't own this property, this contract that you have is technically not valid because Betty Sue has no authority to sell. So once Betty Sue gets appointed, well, that's one thing. But if Betty Sue turns out to not be the personal representative and it turns out to be Joe, well, you need to rewrite that contract. So Joe is the one who's actually selling the property. All right. You might as well go ahead and do it because your underwriter is going to require it anyway. Okay. If the property goes through a summary administration, remember, petition, order, and it turns out that it's Manny, Mo, and Jack who end up owning this property, Manny, Mo, and Jack should be on that property a contract, right? Because they own the property. All right. So make sure your contract matches up to whoever has the letters of representation or risk ownership of the property. Okay. I'm trying to think what other questions there were. I think I covered most of the big ones. Yes, sir. Yes. So the question is, can you sell the property? Can you sell the property if the IRS has a claim? Or
do they actually have a claim once the person dies until their estate is settled?
yeah. So basically what you're asking is the creditor, the IRS is a creditor of the estate. Okay, that's a really good question. So creditors are dealt with as part of the probate process. We have to give notice to the creditors, and it's a 90-day notice. We give direct notice to the known creditors, and we publish in the newspaper for unknown creditors. It is usually known if the IRS is a creditor, largely because they've already filed a lien on that property. If it has gone that far, they have filed a lien, and that will have already been determined by that title search. And yes, the IRS will get paid first from that sale. First. Yes. And then followed, of course, by mortgage, everybody else. So they are not necessarily going to hold up the sale, but they will affect the distribution of the proceeds, let's say. Other creditors. So if I'm dealing with like a lot and the lot's like $5,000, I will often warn my clients, well, technically this $5,000 lot, you know, you can go ahead and sell it, but we do know that there's some creditors out there. How do you want to deal with this? You know, you may have to pay them if they file a claim. A lot of times my clients are like, let's just go ahead, sell the lot. We know we have to pay them anyway, but we're also not going to have the money to pay them if we don't sell the lot. So it's kind of 6 of 1, half a dozen of the other. Homestead property obviously is a little bit different when it comes to creditors other than the IRS or like mortgage. With homestead, it is creditor exempt. So again, that value is 0. So if a Visa, MasterCard, whatever, they file a claim in the estate, and they say, you owe us $50,000 and all I have is a piece of homestead property. Sorry, Visa, MasterCard, but you're not getting paid. Now, if there's cash, assets, you know, there's cash in the bank, that's different. You know, they go after cash all they want, but not the homestead property. That's the beauty of our homestead. So that's a really good question. Any other questions?
I have a question. If we're sitting down, you know, for a listing appointment and, you know, we're meeting with somebody and they say, hey, it's in probate and they're claiming to be like, you know, in charge of the estate, what kind of documentation should we be asking for or proof? What steps should we take to make sure we're not getting bamboozled either by like an aggravated family member that has no right to the property?
So the question is, if you're sitting down and somebody's saying, hey, I have the authority on behalf of the estate to sell, what documentation should you be asking for? The documentation would be letters of administration and order appointing the personal representative. Okay, if it's if it already went through a summary administration, quite frankly, you know, you can ask them for the copy of the order, or you should be able to look on the property appraiser's website and see that they've already, you know, changed the title. If there's a little bit of a delay, you can look up the case and see the order was entered. But if it's going through a formal probate, ask for copies of those letters of administration and orders. Yes,
I
ma'am.
actually have a came out of probate, and I got a letter of administration from the gentleman's father. New York. And that estate is another lot, which is still not in the estate of the house that the homestead is. There's two properties sitting up. Homestead is in the name, the estate of. That lot is still in just the name of the deceased. Is that going to be a problem?
So what should, so it looks as if, so what's going to happen is it looks as if the property appraiser has not maybe picked up that there's that estate. No, I'm assuming the lot is here in Florida.
It's right next to the house.
Oh, okay. Yeah, sometimes it's weird. Sometimes the property appraisers will label one as in the estate of and the other one's still in the decedent's name. Sometimes they will pick up that there is a probate going on one, but not the other, and I'm not exactly sure why. But it shouldn't be an issue at all. What I can tell you is that if they decide that they're not going to sell that property, ultimately what should happen is the property should be deeded out of the estate and into the names of the beneficiaries.
Okay.
Sometimes that last little step is missed. You know, a probate was opened, estate of Bobby Jones.
Right.
Probate's closed. 10 years later, they go to sell the property and it's still in the estate of Bobby Jones. Bobby Jones' estate's been closed. They should have just done a PRD and getting the property to the kids.
Got more questions.
Oh.
So I should be able to look that up on the Lee County clerk of court, that with the case number.
Yes, if there's an open probate here in Lee County, you should be able to go to the clerk of the court
Okay,
and look it up by case number.
I'm not sure if it's still open or not. There's also a boat, a car, a motorcycle, and a garage full of tools that father in New York wants me to assist in disposing of. I'll take the boat.
So she take it, I'll buy it.
What documentation do I need if I am calling on consignment, boat consignments, motorcycle consignments, and a car dealership? What documentation do I need to cover my lot?
Right.
I shouldn't be doing it.
So the question is, I'm assuming the personal representative is asking the agent to help out with the sale of boat, vehicles, and contents of the house.
Right.
And she's asking what kind of documentation that she should be asking for. So honestly, what you should be doing is referring the personal representative to really an estate appraiser. These estate appraisers know the documentation that is needed to, well, they know the best way to get rid of the contents of a house. They're very good at going garbage, sale, and, you know, just donate.
Right.
Okay. When it comes to the sale of vehicles, my understanding is that you have to have a license to be able to sell those vehicles. If you want a recommendation of a really good estate appraiser that I have used, I can give that to you. Yeah, he will handle all of that. And actually, for everybody, his name is Rick Smith of Crimson Estate Services. What I usually do is I will refer him to handle the property, the contents. He will handle the disposition of these motor vehicles. and the boats. And there's documentation he will get from the personal representative that will allow him to be able to sell these vehicles, go to the DMV, transfer the title and everything, because usually these people are out of state. So he's able to do that for them here. Punt that. You don't want to be involved with that in any way, shape, or form. First of all, you're going to drive yourself nuts.
Yeah.
Second of all, if there's any kind of, if it goes south,
Mm-hmm.
yeah, you're going to be left holding the bag. So punt to the professional.
I'll give you my card if you could email. me.
Absolutely, absolutely. Yeah, Rick is a consummate professional and he's done an amazing job with all the estates that I've sent to him. So he will.
That frees up my time to do business.
Yes, yes, you are a realtor.
Yeah.
Yes, I can't do that for you, but I know an amazing person who can. Yes.
So here's usually what, because I'm the road. Somebody calls up one of our agencies, my aunt just died, and want to sell the house. I'm going to be the executor.
Yes,
I'm going to.
you're going to be the executive.
Not is the executor. What do we say?
So the question is, they get the phone call, somebody says, my aunt just died, I'm going to be the executive. So the answer is going to be, well, I know an amazing attorney,
Yes.
and I'm going to give you her telephone number, 239-785-3800.
Yes.
Truly,
They really
That's-
can't list it until.
yes, ma'am, they
That's-
cannot, they
that's-
should
that's the
not.
part of my-
Correct, because what's gonna happen is if you start the listing, then you're gonna go to Kathy. Kathy's gonna have to make the telephone call to say, I'm so sorry, but we can't close. And then you're gonna have to call the client and say, I'm sorry, you don't have the authority to close. And I know a really good attorney. So you might as well just cut them off at the knees. And you know what? It's okay, because, I usually, when I get these phone calls, and especially if I get like, if I get a referral from land seller or what have you, I know time is of the essence. You guys all want to get paid, you want to get paid.
Mhm.
I can pretty much do an intake right there. I know all the information that I'm looking for. Within usually 5 minutes, I pretty much have a clue as to which way we need to zig or zag here.
Mhm.
And we can get the ball rolling pretty quickly.
Because I got another one coming up too.
If everybody cooperates. we can-
Specializes in.
Yeah, that's right. Somebody's got to do it. I love dead people. I'll get you before. It's okay. They're usually stressed out when they call, and it's, and a lot of times it's amazing. People have owned these, they own these properties and they forgot about them. Nobody ever knew about them. And, then all of a sudden it's like you're getting a tax bill and they paid on them for years, and now all of a sudden it's like, what the heck am I supposed to be doing with this? And I don't want to be paying these tax bills. How do I get rid of it? And they want to just get rid of it. And they're not too pleased that they have to jump through a couple of hoops before they get there. But we're going to make it as easy as possible. Okay. And it doesn't have to be difficult. And a lot of times with, especially these lots and some of these houses, it really isn't. Every now and then I have run into some of these cases. Well, I have 4 of them right now. Grandma died. She owned the house, homestead property. She left behind 2 daughters. Daughters moved into the house. They never did anything. They just moved into the house. Daughter number 1 dies. Oh, no, it gets better. Daughter number 1 just continues to just live in the house. Then she dies. Now I get the call from my client who says, what do I do? So we got to start with grandma. Okay, so we have multiple probates that need to occur because this is what should have happened. Starting with grandma, the daughter should have taken grandma's house through probate, so they owned it. They didn't. So now we have to take a step down through. And sometimes we need a little chart to get there. So occasionally we'll have these wrinkles. Once again, everyone has to just be patient sometimes because we do have to take a step through all of this. But if everybody starts giving us the paperwork, we can try to move it as quickly as possible. The major hiccups we run into, I have a gentleman who was left $1. Just $1. Needless to say, he's pissed. He's very upset. But he's also an interested party, which means he's entitled to notice on everything that we send to the court. Does he sign anything? So we have to provide formal notice. What does formal notice mean? Oh, that means I send something off and I have to wait 20 days before I can do anything. Yeah, 20 days. 20 days. So those kind of things can take some time. But that is not usually, thank goodness, the norm. There are some people who will sometimes fight about things. It's usually the stupid stuff. Yeah. But it's not always the property. It's usually the stupid things. It'll be the spoon collection. The 3 pieces of jewelry that my appraiser said, this is really awful jewelry. Who would want it? They were fighting over. Real estate is not so bad because it's either you're going to sell it or I'm going to buy you out. That's pretty much it. Okay. So if they don't have the money to buy out, then we're selling it. I mean, it's as simple as that. So the real estate's usually not that big of a deal. It's the other stuff that they fight about, and that's okay. You can sell the property and you can do your thing and you can just exit stage left while they just fight about the spoons. I got stuck dealing with the spoons, but you can go ahead and sell the property. So
What if one of the buyouts needs to get a loan to buy out the others? Does that work out? I mean, does that close?
Yes. So the question is, what if one of the beneficiaries, I'm assuming, needs to get a loan to buy out the others? Yes. Yes. As you know, it's happened quite a bit. It's never usually an issue, as long as everybody's patient, as long as the other beneficiaries are patient about it. Yeah. One of the first things that I always do is I have my clients get an appraisal on the property. It's not an appraisal for sale. It's an appraisal for the tax purposes, for the stepped up basis, the tax purposes. Sometimes they don't sell the property right away. Maybe they'll sell it 10 years from now, but we would need to know what was the price of the property on the date of death. Yeah.
Yeah, another question. It does go through a will that there's a property. You have to advertise or a deal just be made with a neighbor.
So the question is, if a property is going to be sold in the estate, does it have to be listed on the MLS? The answer is maybe, maybe not. So obviously the personal representative's job is to act on what's the best on behalf of the estate. So typically what we're looking for is an arm's length transaction. So if selling to the neighbor means that it's going to be a cheap deal, and it's going to cheat the beneficiaries out of more money than if you put it on the MLS, then the answer is no. Now, that being said, sometimes doing that kind of a deal can cut some costs and put some money in their pocket. Buyouts between beneficiaries obviously cut some costs as well. They're not advertising their, unfortunately, they're not paying you guys. So they will often go that route to, well, we're just going to buy it. But as long as the deal is going to put the most money in the pocket of the beneficiaries, it's usually okay. There would have to be some real reason as to why they would not want that to happen. I don't think I've ever seen a situation where they would say, sell it to the neighbor on a cheap fire sale. I can't imagine anybody would.
There's fair market value evaluation.
Yep.
And neighbor wants a buffer.
Sure.
Doesn't want anyone else. We really got to put out an analysis. There's no law that says 48 hours of public notice.
No.
that this is out. Okay.
No. In a market like this, though, I think that would be a hard call to make. I mean, this is so hot. the neighbor comes in and says, oh, I'm gonna pay $350 right now. You guys know his $350 could be $370 in 15 minutes. I mean, it's that hot right now. I don't know that anybody would want to make that call. But if the market wasn't as crazy as it is now, maybe that would be an okay deal. It's like, well, we take his $350 now versus spinning our wheels for the next, month or so, and everybody just wants their money now. That might be a good call. I don't know about this market, but you know what? You guys are the experts. You guys could probably make that call and that decision, and a client's going to be relying on you to obviously put the most money in their pocket.
Thank you.
So there's no law.
Yeah.
It's kind of publicly.
Not about.
Not another question. Somebody, did we break the time on that?
No.
Sorry.
No.
Okay. The.
You got distracted.
I know, I got distracted in my thoughts. I'm sorry.
That's okay.
Well, I'll jump over to trust and touch on trust, because a lot of times we see in the tax rolls, it'll say trust. But we don't know if it's, what kind of trust it is. How do we know, so that we know who has to do what? Is that, am I making that clear? Like living trust, revocable versus irrevocable, blah, blah, blah.
Yeah. So JJ's question is, sometimes you'll see in the tax roll, the property is in a trust, but you don't know what kind of trust it is. No, you don't. Sometimes you can look at the deed. Sometimes you can look and it'll tell you in the name of the trust, whether it's a revocable trust, an irrevocable trust.
Does it matter?
No, not necessarily for your purposes. So really irrevocable, revocable trusts, kind of the way they sound. A revocable trust is usually something that can be changed by the creator. An irrevocable trust is something that is typically not able to be changed. But I say this with generalities because there's a lot of different kinds of trusts out there. And I could be here for weeks talking about trusts by themselves. So I'm just going to say that in general. How does this affect you? It doesn't necessarily affect you unless for some reason there's a lack of language or language in a trust that does not allow for the sale of property. Yes. With a revocable trust, you typically don't have any issues.
Here's the next question you get from a lot of elderly. One of them died. Does that affect homestead? And someone put their property into a trust and it's still paying homestead?
So the question is, can somebody put their property into a trust and claim homestead? Yes, they can still claim homestead. A lot of times when they do the deed, okay, so when they do the deed, changing your deed, the property appraiser will sometimes come back and say, hey, you need to reclaim the homestead exemption. I'm going to deviate on that topic a little bit, and as an estate planning practitioner, the appropriate way of handling homestead property is not to transfer homestead property directly into a trust. There's a variety of reasons that you should not do that. One is an issue that has lately been raised by underwriting. So the issue that has been raised by underwriting is homestead property naturally devises to heirs under the Florida Constitution. Okay, so if I give my property away to the trust, is there an argument that I violated the Florida Constitution? If you ask an underwriter, the answer is yes. If you ask an estate planning attorney, the answer is no. But we have to work together. Okay. I started the new year with that issue with the property that was in the trust and an issue at closing. Okay. So for that reason, that's one of the reasons I do not put my properties directly into a trust. The second thing is Medicaid. Homestead property is a exempt property for assets for Medicaid. It doesn't count as an asset for Medicaid. But if I start transferring that asset, that 5-year look back period, you see those commercials on TV, right? start the clock. Okay, right? So we work around that. I'll give you a little primer. Enhanced life estate deed. Enhanced life estate deed. We do an enhanced life estate deeds. Basically, the person is transferring the property from themselves to themselves. Okay. There are two parties. Tenant number one, tenants, life tenants. This is an enhanced life estate. They can buy it, they can sell it, they can paint it blue if their HOA allows them to. They're the only persons who have an interest in the property. When they die, party two is sitting there waiting for them to die. That's the remainderment. Now, in that case, the remainderment will be their trust. Okay, the property will roll into the trust upon when they die. An enhanced life estate deed transfer does not count for Medicaid purposes. It's not an improper transfer against the Florida Constitution for the underwriters.
That's called a ladybird.
So an enhanced life estate deed, the language, if you see any of mine, you will see reserve the authority to encumber, blah, 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 it's all in there. And then you will see the remainder is, it's actually them as the trustees of the trust. Okay. Now remember, the trustees of the trust is a revolving chair because I've named a successor trustee. Who that is when these people die is who that is when these people die. All right. But it's in the trust. So that's how we do this work around. Other states, they can just throw the property into the trust, right? I live in Ohio. I just transfer my property into the trust. They don't even think twice about it. But we have beautiful homestead. We can't do that. So that's how we do this. That's the correct way of doing it.
So how does that life estate read that? Is the remainderment the trust? Is that what you said?
Yes. The question is the remainder in the trust? Yes.
Okay.
Sometimes if there isn't a trust, sometimes the remainder may be the children.
Right.
The key to it though is the person, Mary, Joe, whoever, they reserve the right to sell the property, to do whatever they want with the property during their lifetime. Yeah. If you see the LE on the property appraiser's website, life estate. I will tell you, life estates are created sometimes by different situations. Not always pretty. I have a client whose dad, elderly father, got married 6 months before he passed away, and he owned homesteaded property. Well, the minute he got married, the floozy, as my client likes to call her, inherited the property. She had rights to the homestead property because she's married, right? So, oh boy, they hate the floozy. All right, but the floozy has rights. She has a life estate in the property. Well, they would like the floozy to leave. Well, the floozy's not leaving. All right, so in that case, she's the life tenant and they're the remainder. But this is a different kind of life tenancy. All right, it's not an enhanced life estate. All right, it's completely different. And these are ugly. These are kind of ugly. Nobody likes these kind of life estates. But this is what happens when dad gets stuck into the floozy and doesn't do any estate planning before he passes away. So that's all I'm going to say about it. Now I'm going to patent law. So
reverse mortgages, put a big ink in this.
Reverse mortgages. Okay, so all right, reverse mortgages do have their good points. I have seen them do some good things. I had a lady a number of years ago. She was going to be out on the street. She did a reverse mortgage. She saved her home. She did. Here's the downside to reverse mortgages. When you take out a reverse mortgage in an environment like this, they're allowed to borrow 50% of the equity of the home. So if right now the house appraises at $400,000 and they borrow $200,000, what happens 10 years from now when that house is not $400,000 and it readjusted itself back down to $250,000? What ends
is left to the heirs.
What ends up happening is that it gets to the point where they owe more on the property than the property is worth. And that reverse mortgage company does start sending statements, by the way. It will get to the point where when they do die, it's literally a, here's the keys. There is nothing left to give to heirs. Now, in some situations, who cares, all right? The older person clearly needed it. In other situations, it was just a really bad move because they didn't understand it. And I guarantee you the reverse mortgage person did not tell them about what happens when the market readjusts, right? I saw a lot of the reverse mortgage. Remember when we did up the big peak and then we did the kabooey? I saw a lot of those. Okay. Reverse mortgages, if properties are in trusts, a lot of times the reverse mortgage companies will want us to deed the properties out of the trusts back to the individuals. And we just put it back in the trust. Well, just put it back in the life estate. But yeah, they have their places, and they can save people in situations where they might end up, but they have to be approached very, very carefully. Very carefully. Yeah.
Any
That's a
other
lot of
questions?
information.
I
know it is. It's a lot. It's a lot. Yeah. So I think really the takeaway for you guys is number one, just verify the person who is in front of you. You know, who are you and how are you connected to this property? And do you have the authority to put your name on this contract? Are you going to be able to make it binding? Okay. And if not, take a step back. Okay. You may need to wait. And that could be very daunting when they're ready to move, but you're gonna get a wall put in front of you anyway, so you might as well just stop it right there at the door. All right, but it's gonna be okay because you're gonna connect them to the people who are gonna be able to get them there anyway, and you're gonna be the hero. Okay, as opposed to, oh yeah, we got this contract, and then they're gonna get the bad news and they're gonna look at you and go, why didn't you tell me in the beginning, right? So you want to be the hero, you don't want to be part of the problem. So just take it.
Can I just shoot out a question from a buyer's agent standpoint, not a listing agent standpoint? Had a deal, the owner is from Germany. The daughter had power of attorney according to what the listing agent said. 4 months later, the listing agent didn't do the work that they needed to do to make sure that that cleared here. So we have foreign trust stuff going on, and we're trying to sell a Fort Myers Beach property here. And in all of that, I assumed that the listing agent had their stuff all together and that they had proper documentation. How do I, as a buyer's agent, not drag my customer through 4 months of, well, we're trying to get this done?
Well, for power of attorney, that doesn't extend past that, correct?
So the couple questions. So the first question is, if I am the buyer's agent, how do I make sure that the listing agent has all their ducks in a row so I'm not wasting my time and my client's time? And then the second question, which tied in or the second statement really was, power of attorney doesn't extend beyond that. So yes, so number one, yes, power of attorney dies with the person who gave it. Right? By $5 for every time somebody said, my mother died in power of attorney, I'd have retired years ago. Okay. So yeah, that's a no. So yes, if you know that there's a probate, there's something that's out of the ordinary, I would stop and I would ask for that documentation. Okay, where are you in the process? Oh, there's a probate. Okay, has your client been appointed the personal representative? Where are you in the probate? Is there a will? Has there been a petition? Has there been a motion? Do they have clearance by the court to sell this property? Ask them, show me the documentation, because that'll give you a good idea of what hoops that still need to be jumped through to get to the closing.
Yeah, and that's what happened. The German documents were clear to be able to sell in Germany, but they didn't translate down. There was another series of documents that had to come to the states and, 5 attorneys, some in Germany, some here, trying to make that work. And none of that was done before the house was put on. the market.
Yeah.
So,
Oh, you remember.
Say that the vehicle, say that the receiving passed in September. It took until the end of November to get the personal representative appointed. Can the vehicle be repossessed by the bank during this time? I mean,
So the question is, if person died in September, took till November for the letters of administration, can the vehicle be repossessed? The answer is yes. Yes. Will it? Yes. If you don't pay the bills, yes. Same thing with, there's a condo and HOA. I'll tell my client, somebody needs to continue to pay the condo and HOA dues. They will foreclose quicker than a mortgage will. Mortgage company, quite frankly, they don't care where the money is coming from, so long as the money keeps coming.
Yeah.
Make sure those continue to be paid. We'll figure out who's getting, how we're getting reimbursed at the end of it, but keep them getting paid.
so what happens if the bank is refusing to cash the mortgage checks that person represented us said?
Typically, if it's coming from the personal representative, they will not refuse to cash the check. Typically, yeah, because it's coming from the personal representative. Yeah.
What about before this person representative can the bank refuse them?
They could, but they typically don't. All they care about is getting their money, to be perfectly honest with you.
$50,000, they would take $475,000.
They might, but they still have to go through the foreclosure process. Yeah, that will take months.
Amy, great job.
All right, very good.
So much.
Yes, all right. So
So
I
I
will-
presentation was full of clarity.
Very good.
I was on the edge of my seat, and how often do you hear an attorney say, this doesn't have to be difficult? Okay, let's get down to it. It doesn't have to be difficult, right, Amy? Well, thank you, we appreciate your time.
Yes, excellent. If you guys have questions at any point in time, don't hesitate to reach out. If you feel like you're in a pickle with your clients, that you've been asked a question, you can always call me. I know it's like sometimes you're in front of somebody and they need an answer right now, and you're like, hang on, I'll phone a friend. It's okay. Give me a
And how
call.
incredible that is that you can really call Amy and she really will take your call and give you direction, because
That's a partnership.
Very valuable partnership. So thank you very much.
All righty, very good. Thank you guys for having me.